Thank you, Madam Chairwoman. Thank you, Mr. Secretary. Following up on Mr. McHenry's questions about Tim Geithner's involvement in this, you stated that you kept him, once he was nominated, you kept him informed. Right. However, we have notes from Joe Price, who is the Chief Financial Officer for Bank of America, basically chronicling the conversation that you had with Chairman Lewis and yourself. And in those documents, he says, quote, "Fire BOD if you do it, irresponsible for country, Board of Directors." Tim G. agrees. In those conversations, did you ever invoke Tim Geithner's name or suggest in any ways that he was on board with your view on this to apply additional pressure to Mr. Lewis or Bank of America?
I tell you, I've sure got no memory. I've sure got no memory of that, just none whatsoever.
You don't remember mentioning Tim Geithner in the conversation with Mr. Lewis?
I don't remember it. Those are, those are Joe Price's notes, and someone would have to ask him. I don't even remember talking to Joe Price. I remember talking with Ken Lewis, and as I said, I posted Geithner. I didn't look at him as a decision maker, and I just don't have memory of in that kind of detail.
So you would never have you never used him, to your recollection, as additional pressure, that he was on board?
Yeah, I don't. I sure don't recall that.
Okay. There seems to be a lot of confusion, or it seems we're arguing over semantics over whether or not you threatened Mr. Lewis or Bank of America. And I don't think it's necessary that we argue over the semantics of a threat. I think you've been very clear, at least in your earlier testimony, that if they went forward with invoking the MAC, that you would have moved forward with attempting to remove him from his position.
Well, I wouldn't have moved forward. I did not have the authority to do that. What I said to him was, I said to him, if he did something so irresponsible,
that was, in your view, irresponsible.
I believe the Fed could do that as his regulator.
And you further clarified that you felt that would be irresponsible, invoking the MAC.
Yes, absolutely.
Okay.
Very clear.
Okay, that is clear. Okay. So what maybe threat isn't the correct word. Maybe he felt pressure. There was, I mean, is that a fair term, that he was?
I'll let you. I'd rather just tell you what I said and let you characterize it.
Okay, fair enough. I would like you to respond then to Mr. Bernanke's testimony. Chairman Issa, or Ranking Member Issa, asked him if there were threats, which I know we don't like that term, or if people felt threatened to go through with the deals, it's okay because it worked out. Do you agree with that? Bernanke responded, no, sir. In other words, it would not be appropriate for Ken Lewis and Bank of America to feel pressured. Given Bernanke's acknowledgement at our last hearing that threatening to fire Bank of America's management to get them to go through with the merger would have been inappropriate, are you prepared then to take responsibility for issuing such an inappropriate statement?
I'll tell you, I certainly take responsibility for what I said, and what I said, I think it logically followed from, I laid out a train of events, and I think it logically followed. That's what a regulator should do. I would say, I think Chairman Bernanke, when he testified here, last month, I think he acknowledged that if someone made a decision that harmed their company, they deserve to be held accountable, and that's certainly what I was trying to communicate to Ken Lewis.
You stated earlier that you took issue with Bank of America's reason for invoking the MAC. Did you ever personally read their legal justification?
Nope.
And you stated that you relied on the legal basis, or rather the Fed's legal staff, for their view on the MAC as your justification. Are you aware, do you know the names of the legal staff that you relied on?
I listened in and participated in a number of calls where I heard the legal staff, and You know, I do know some of the people, yes.
Do you know if any of that legal staff had background or experience in mergers and acquisitions?
I know they were experienced lawyers. I do not know their specific experience.
Well, I mean, come on now. There's a difference between being an experienced lawyer and an experienced lawyer in mergers and acquisitions that would know whether or not a company has the legal basis to invoke the MAC clause.
I'll tell you one other thing. Okay, one other test. I've participated in deals and in markets for 32 years, and when I hear a lawyer say to a company, "What's your legal justification?" After 2 shareholder votes, and with a MAC that's structured this way, and I'm not getting very much back on the other side, and I'll tell you something, as someone who's been around in the markets, everything that I heard squared with my instincts and judgments.
Were you aware that Bank of America had successfully invoked the MAC less than a year earlier on the Sallie Mae deal?
Was it after shareholder votes in a Delaware company?
Well, I guess what I'm trying to understand is if they legally had justification and legal expertise to invoke the MAC clause once, I would question why they would come forward and justify that they could do it in this instance and be wrong.
I've told you how I made my judgment, and that's how I made the judgment, and I think it was the right judgment.
Okay, thank you.
Thank you. Gentlewoman from Ohio.
Thank you, Mr. Chairman. Mr. Secretary.